Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers lawful orders, the right to film, and resisting, and is brought to us by Four Corner Fist in the Air's channel. Be sure to check out the description below and give them the credit that they deserve. On February 6, 2023, Officer Callie Boyd and other officers with the Farmington Police Department responded to a call regarding an individual named Jay DeLuzio, who had returned to the office of Farmington, New Mexico attorney Brant Thrower after he had been trespassed from the property for making repeated threats. According to an affidavit written by Officer Boyd, Mr. Thrower reported that Mr. DeLuzio had told someone on the property that he had found a gun, and before arriving at Mr. Thrower's office, San Juan County Dispatch informed Officer Boyd that Mr. DeLuzio was listed in a database of individuals who suffer from mental illness and/or substance abuse. Mr. DeLuzio also called San Juan County Dispatch and advised that he was in the parking lot across the street from Mr. Thrower's office and that he had a knife on him. Mr. DeLuzio then said he wanted to ram his truck into the building, became very agitated, and hung up the phone on the dispatcher. Upon their arrival at the office, Mr. Thrower informed the officers that Mr. DeLuzio had a traumatic brain injury and had not been taking proper medication for some time. Now, while the Farmington officers were speaking with Mr. Thrower inside his office, local First Amendment auditors Justin Chi of Four Corner Fist in the Air and Adam Howell of Press for Transparency saw the police vehicles parked outside Mr. Thrower's office. Interestingly, we covered another audit of Mr. Cheese in a previous episode of ATA, and I've included a link to that episode in the description of this video. Unaware of any of the details regarding the reason for the police response, the auditors began to film. Mr. Howell attempted to film Officer Boyd's computer screen from outside of her vehicle, and she came out and shut her computer upon seeing what they were doing. Mr. Chi and Mr. Howell continued to film, and the officers eventually went back outside and crossed the street to attempt to speak to Mr. DeLuzio and de-escalate the situation. The interaction that followed was streamed live by Mr. Chi on his YouTube channel.
I don't mind if you guys film, but can you guys come across the street for me, please?
Can you go somewhere else?
Hey, sir, I don't mind if you
Go
film,
somewhere else.
but right now, can you go across the
Can you
street
hear
for me,
me?
please?
Can you hear me? Can you
So,
hear me? Can you go somewhere else?
sir, I need you to cross the street.
You
while
get
we
your name and badge
investigate,
number?
okay?
Name and badge number?
Young
I'm not gonna be
R924.
quiet. Can you
Young?
just go across the street for me?
9204.
Are you our
924.
924. Appreciate it. Thank you.
Go across the street. Sir, I need you to go across the street for me. For my safety, I need you to go across the street while I talk to this gentleman. He does not want to be filmed.
Upon Mr. DeLuzio becoming more agitated at the auditors filming in close proximity, Officer Boyd asks them multiple times to film from across the street, and they refuse. The 10th Circuit Court of Appeals, which has jurisdiction over New Mexico, concluded in the 2022 case of Irizarry versus Yahia that, quote, based on First Amendment principles and relevant precedents, we conclude there is a First Amendment right to film the police performing their duties in public. In this case, the court also found that, now quoting again, a peaceful recording of a traffic stop in a public space that does not interfere with the police officer's performance of their duties is not reasonably subject to limitation, and that the authority of the government to limit the exercise of First Amendment activity on a public street is, quote-unquote, sharply circumscribed. However, it also noted that, now quoting again, this right is subject to reasonable time, place, and manner restrictions, and in determining that individuals filming a traffic stop were engaged in First Amendment protected activity, the court heavily emphasized the fact that they did not interfere with the traffic stop, hinder law enforcement, or impede officers from performing their duties. Other courts have noted a similar authority of officers to restrict filming that interferes with an officer's performance of their duties. For instance, in the 2012 case of ACLU of Illinois versus Alvarez, the 7th Circuit Court of Appeals explained that, quote, it goes without saying that the police may take all reasonable steps to maintain safety and control, secure crime scenes and accident sites, and protect the integrity and confidentiality of investigations. While an officer surely cannot issue a quote-unquote move-on order to a person because he is recording, the police may order bystanders to disperse for reasons related to public safety and order and other legitimate law enforcement needs. And although the court recognized the constitutional right to record a police officer, it clarified that, quote, nothing we we have said here immunizes behavior that obstructs or interferes with effective law enforcement or the protection of public safety. Likewise, in the 2014 case of Garecki versus Begin, the First Circuit Court of Appeals concluded that, quote, reasonable restrictions on the exercise of the right to film may be imposed when the circumstances justify them. The circumstances of some traffic stops, particularly when the detained individual is armed, might justify a safety measure, for example, a command that bystanders disperse, that would incidentally impact an individual's exercise of the First Amendment right to film. Such an order, even when directed at a person who is filming, may be appropriate for legitimate safety reasons. It is important to note that the court also clarified that, now quoting again, a police order that is specifically directed at the First Amendment right to film police performing their duties in public may be constitutionally imposed only if the officer can reasonably conclude that the filming itself is interfering or is about to interfere with his duties. However, in this situation, the filming itself appeared to be provoking a mentally unstable and potentially armed individual that the officers were attempting to calm down. As such, it is likely that a court would find that Officer Boyd's order for the auditors to film from across the street was a reasonable time, place, and manner restriction, and therefore did not violate the First Amendment.
No, there's no privacy in public, right?
What's that?
There's no privacy in public?
No.
Yeah, you can just let her know. Just let, we're not doing nothing wrong. If they're going to say want privacy, they can need to create their own privacy,
I'm a young one.
Yeah.
That's me. You guys having fun today?
I'm enjoying the day.
Enjoying the day?
Yeah.
You guys live right now?
Oh, yeah.
Yeah?
Yeah.
Him too?
I don't know.
You don't know.
Yeah.
Sir, I'm gonna need you to go across the
You
street.
want me to get out?
Stay in your car, it's okay.
Can I get
Sir,
out?
I'm gonna need you to go across the street. My investigation.
You hear me?
It's got to be a physical act.
I need you to go across the street.
Stepping away from us, please.
It's Officer Boyd 911.
You want to let them know what Brandsburg versus Hayes is?
What call you guys on, or what calls have you guys been on today?
What's
So
that?
we need to tell you about some case law. It's called Brandsburg v. Hayes. It's a Supreme Court case that basically says that the press has the right to be wherever the public's allowed. And so right now we're on a public sidewalk, which is a traditional public forum. We're going to exercise our right here. We're invoking our First Amendment rights here.
In arguing that the auditors have the right to film from the sidewalk, Mr. House cites the 1972 Supreme Court case of Brandsburg versus Hayes, where the court determined that journalists, just like ordinary citizens, were required to respond to grand jury subpoenas and answer questions related to criminal conduct they personally observe, regardless of any promises of confidentiality given to the subjects of stories. In reaching this conclusion, the court noted that, quote, it has generally been held that the First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. Although Mr. Howell is correct in his assertion that this means that journalists generally may be wherever the public may be, this does not necessarily mean that journalists may always film whatever they want from a public street. As we discussed earlier in this episode, courts have repeatedly recognized the authority of officers to place reasonable restrictions on the exercise of the right to film when the circumstances justify them, particularly based on safety concerns or interference with the officer's duties. Further, the court noted in the Brandsburg case that, now quoting again, newsmen have no constitutional right of access to the scenes of crime or disaster when the general public is excluded, and explained that, now quoting again, it is clear that the First Amendment does not invalidate every incidental burdening of the press that may result from the enforcement of civil or criminal statutes of general applicability. Otherwise, valid laws serving substantial public interests may be enforced against the press as against others, despite the possible burden that may be imposed. Accordingly, it is likely that a court would conclude that Mr. Howell and Mr. Chi did not have a limitless First Amendment right to film from a public sidewalk, and that the officers had the authority to impose reasonable restrictions.
You know the 5 freedoms under the First Amendment?
5 freedoms?
Yeah.
You're gonna quiz me right now, man?
You don't know that? We can teach each
I'll
other.
take a crack at it. Freedom of speech, obviously.
There you go.
Religion, assembly, petition.
What are we doing?
Yeah, the last one.
What are we doing right here?
Educate me on the last one I'm missing,
There
man.
you go. Press.
Press.
Yeah. So if you understand that, you would understand what we're doing here.
Yeah.
Like you said, they can create their own privacy there, but we have a right to film in public. This is, so these are our rights under the First Amendment. And these are supreme law of the land. And
Hey,
starting with
turn that mother. Turn them. I'm gonna be here. Look, look, look. Hey, loser.
that's what's called freedom of speech there.
Oh, bless you.
It does sound a little intoxicated.
This guy, could you?
He totally sounds like he's slurring his words.
Yeah. They tried intimidating you too, right? They tried intimidating you.
She paid
With the female officer.
I think they called another one.
There's another one on the way. You see another one? How's it going?
Can we give them a little bit of space so they can do what they need to do?
I gave him a little just a minute ago.
Can we give them a little bit more? I'm fine with us talking about what's going on, but this is something we just need a little bit of space on.
Okay.
You don't want us to hear or see anything? Is that what's going on?
No, I mean, if we could just take a few steps back, that's fine with me.
Okay. Yeah, you
Now
guys got your
and now that
footstep.
we're here, just so that they don't have to keep looking over their shoulder, and that's it.
We're just filming. That's all we're doing.
I know what you're doing. And that's
Why
fine.
do?
But they can't look over their back and talk to this guy who's kind of upset at the same time. So now that we're here, you're fine.
Okay.
Thornburg. 5 elements. 5 freedoms.
Yeah, do you know what the 5 freedoms are under the First Amendment?
I didn't know I was here for a constitutional test. Yeah, they're just conducting an investigation like he said. You're welcome to film from a safe distance.
Blair, you know the 5 freedoms?
I'm just gonna. I don't want to engage. Okay, I'm just
You
here.
did engage with us.
Okay, I'm gonna pay attention to the officers, and you're allowed to do what you want to do, and that's fine. Okay.
So you're saying you don't know the 5 freedoms?
Freedom of religion, freedom of assembly, freedom of press, freedom to petition your government for redress of grievances, freedom of speech.
Thank you. Thanks, sir.
We'll see you guys. Be safe.
Yeah,
in
you
your
guys are
travel.
you guys are dismissed. Don't go violate anybody's rights out there.
After Mr. DeLuzio left the parking lot, Mr. Chi and Mr. Howell were allowed to leave the scene without further incident. However, on February 7th, 2024, a judge found there was probable cause to believe that Mr. Chi had violated Section 18-7-2A1 of the Farmington Code of Ordinances, which prohibits resisting or obstructing officer, and an arrest warrant was issued on February 8th. Mr. Chi was arrested on February 9th, and his arrest was captured on body camera.
Hi, Mr. Chi.
Morning. How are you?
Hi.
Good. Good. You have a warrant for your arrest, Mr. Chu.
You need to lock up anything or anything?
Yeah.
Okay. We can
Hold on, I got my earphones.
I'll get it for you. I'll get it for you. You're good.
go and put your hands behind your back.
I got a missed call.
Yeah, we can do that.
This is warrant for?
It's from municipal court for resisting.
Okay, Mr. Chi, I'm gonna walk you in front of my unit.
And then
I'm
we'll
gonna double
confirm
check.
this before
yeah, I will pick it up.
we do any type of searches or anything like that. We'll get your phone if you're okay with us grabbing it from it's in your pocket. She's just going to double lock your cuffs. We'll confirm the warrant, however you grab your phone, and then make a phone call right here.
I'm just gonna loosen these up. I did them a little too tight.
The officers inform Mr. Chi that he is under arrest for resisting. Section 18-7-2A1 of the Farmington Ordinances states that, quote, resisting or obstructing an officer consists of resisting or abusing any peace officer in the lawful discharge of his duties. This statute mirrors the New Mexico state resisting statute, which is codified in Section 30-22-1 of the New Mexico statutes, and states that, quote, resisting, evading, or obstructing an officer consists of resisting or abusing any peace officer in the lawful discharge of his duties. In the 2019 case of United States versus Romero, the 10th Circuit Court of Appeals, which again has jurisdiction over New Mexico, explained that, quote, the New Mexico Court of Appeals has so far interpreted the phrase resisting or abusing to prohibit 3 types of conduct: physical acts of resistance, the use of fighting words to attack an officer, and the refusal to obey lawful police commands. For instance, in the 1995 case of State versus Diaz, the Court of Appeals of New Mexico concluded that, quote-unquote, quote, resisting refers not only to a defendant's overt physical acts, but also to the failure to act when refusing to obey lawful police commands, such as to drop a weapon. Likewise, in the 2006 case of City of Roswell versus Smith, the Court of Appeals of New Mexico affirmed an obstruction conviction under an equivalent ordinance based on the defendant's refusal to leave a fast food restaurant parking lot after being ordered to do so by an officer. As such, if a court concluded that the order to film across the street was lawful, it is probable that it would also determine that the auditor's refusal to comply would constitute resisting. In addition to the arrest warrant for resisting, a bench warrant was also issued for Mr. Chi for failing to comply with the terms of his probation for a previous conviction. On January 24, 2024, Mr. Chi was sentenced to 362 days of unsupervised probation after a judge found him guilty of criminal trespass for failing to leave a closed public park where he was filming after hours. And one of the terms of his probation was to avoid future criminal violations. If you're interested in learning more about this encounter, I've included a link to Mr. Chi's live stream of his trespassing arrest in the description for this video. On February 21st, 2024, Mr. Chi was sentenced to 66 days for his trespassing conviction. After serving his full sentence, he was released from the San Juan County Adult Detention Center on April 25th, 2024. And as of the date of writing this episode, the resisting charge is still pending. Mr. Howell was also arrested for resisting on February 12th, 2024, and he was released the next day. As of the date of writing this episode, the criminal charge against Mr. Howell is still pending. Overall, the Farmington officers get an A for maintaining professional but firm demeanors throughout the encounter and demonstrating respect for the auditor's First Amendment right to film while also de-escalating a potentially explosive situation. Although Officer Boyd asked the auditors to film from across the street in order to attempt to defuse the situation with Mr. DeLuzio, she made it clear that she had no issues with the auditors filming and simply ordered them to do so from a distance that did not interfere with her efforts to de-escalate a troubled, agitated, and possibly armed individual. And while I do not believe that pursuing criminal charges against the auditors was absolutely necessary, the officers were almost certainly within their authority to do so, as a judge found that there was probable cause for a resisting charge. Clearly, this was not the first time that Mr. Chi has run into legal troubles with his auditing, and I can understand why the Farmington officers would choose to pursue a criminal charge in this situation, particularly if they have had repeated issues with Mr. Chi and Mr. Howell. Mr. Chi and Mr. Howell get an F for maintaining an antagonistic demeanor throughout the encounter, refusing to comply with the officer's orders to film across the street, and likely committing a crime in the process. Not only did the auditors demonstrate a fundamental misunderstanding regarding the authority of officers to issue reasonable restrictions on the right to film, but they also refused to comply with those restrictions. The auditors had no idea what the situation with Mr. DeLuzio concerned, but they chose to assume the worst of every officer involved, concluding that the officers were simply attempting to restrict their First Amendment rights, rather than control a precarious and potentially dangerous set of circumstances. This encounter demonstrates how biased auditors can find problems when they do not actually exist, and also land themselves in extensive legal trouble when they attempt to conduct audits that exceed the bounds of their First Amendment rights. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.